This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutzke is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutzke.
Todd Lutzke from the law firm of Cushing & Dolan now joins us for Ask Todd. This is the segment where you get to ask Todd your estate planning questions live on air right now. Phone number here in the studio is 888-205-2263, so get calling if you have a question for Mr. Lutzke. The earlier you call, the earlier you are in line, so that's always a good thing. Phone number again is 888-205-2263. Again, that's to call Todd Lutzke with your estate planning questions right now. One last time, it's 888-205-2263. Mr. Lutzke, how are you?
I am doing just fine. How are you?
I'm okay.
Yeah? I know you have a trouble, though.
I woke up this morning with an IQ of 75.
Yeah?
Bit of a slow morning.
Yeah, definitely.
Yeah,
it's a slow morning.
Working through it, though. Todd, I want to talk to you a little bit about how to get money to that next generation.
Yeah.
And I just want to run through a couple basic scenarios for you. Let's say that you've got an account. It could be a bank account, brokerage account, whatever it may be. Mm-hmm. If someone says, hey, I just want to add my children as joint account holders on that account, good, bad, or ugly?
All of the above, probably. Actually, not good, just bad and ugly.
Oh.
Yeah, let's leave good out.
Okay.
So just bad and ugly. And here's why. I mean, think about it for a minute. You're not dying right away, right? You're living. You're not setting up your estate plan because you're dying tomorrow. I mean, you're setting it up to pre-plan. And so if I added my daughters to my account and it was joint, right? And I put their names on as a joint owner, I don't care, as you said, whether it's a bank account or whether it's a brokerage account. It doesn't matter. If I do that, first and foremost, have I made a completed gift? Well, luckily, wipe your brow. No, I haven't. But if my kids go into the joint account and as a joint owner, they're allowed to withdraw all the money, one, that's a problem if they withdraw all the money. Never mind the tax.
You wouldn't enjoy that.
I wouldn't enjoy that, number one. And number two, if they do that, now you not only don't have the money, but you made a completed gift. And now you could have a gift tax to pay on top of the fact that they took your money. How about that? No good deed goes unpunished, right? So you don't think of those things, but that could happen. Okay, Todd, none of my kids are bad like that. They would never, ever do that. But, they're both married. They could get divorced. There could be a creditor problem. If they get divorced and their name is on the account, now, well, I did not make a completed gift until they actually take the money. I get that. But they are entitled to half the assets. So if they get divorced, that's going to be thrown into the marital asset mix. And now they're going to have to deal with that. I could lose the money to an soon-to-be ex-in-law. So I'm not thrilled with that. And if all that isn't bad enough, it gets worse. Oh, what if I have 3 kids, but only one kid lives nearby? Oh, well, it's convenient to put that kid on all my accounts because, they're going to help me pay the bills. They're going to access my money if I get older and I need help. So it's convenient. Yeah, except if you die, it goes to that surviving joint owner. It avoids probate, and you now successfully have disinherited all of your other children. Why? Because that child doesn't have any obligation to give it back. Okay, so be leery of that. Yeah, this when you said good, bad, and ugly, I think it's just bad, and uglier is probably the way to go.
Talking with Todd Lutzke from the law firm of Cushing & Dolan. If you have a question that you'd like to ask Todd live on air right now, studio line here is 888-205-2263. Get calling to make sure you get your chance to ask Todd your question. That phone number is 888-205-2263. We're going to take a quick break right now, but when we come back, it's right to your question. So get dialing, 888-205-2263.
Ask Todd with Todd Lutzke, every Wednesday at 10:30, only here on the Financial Exchange Radio Network. You're listening to Ask Todd with Todd Lutzke on the Financial Exchange Radio Network.
Talking with Todd Lutzke from the law firm of Cushing & Dolan. Still got a little bit more space on the phone line, so if you've got a question for Todd, studio line here is 888-205-2263. One more time, it is 888-205-2263. Let's go to Gene in Medway. Gene, you are first up with Todd Lutzke.
Thank you. Todd, you set up 2 irrevocable trusts for us a number of years ago, one for my husband, one for myself. My husband passed away, and it's now an irrevocable trust remainder share.
Okay.
I want to sell one of the houses that is in the trust.
Mm-hmm.
It's out of state.
Okay.
And my son and I are considering a 1031 exchange where we would get a property up here that costs somewhat less and leave me some cash. Now, I'm wondering if we get this new property, does that start the 5-year wait over, or does it go into the existing trust?
So this is exactly what I tell my clients to do. Please call before you act, because if you act, it's harder for me to fix it. Sometimes impossible. Good news here, if you haven't done it yet, the answer is in a nutshell. I'll tell you, yes, we can do everything you said, but let's slow down. First of all, the first part I might have missed. Did you say the 2 trusts that we set up for you back when your husband was living were 2 irrevocable trusts?
Yes.
Okay, so they remain irrevocable even though he passed. That's the important thing. So,
yes.
Okay, so this property that you're selling, where's it located?
It's in Virginia.
Virginia. And is this particular property owned half by your trust and half by your husband's trust, or did we put this in both? Okay. So if this is owned between the 2 trusts, very important. One, both trusts can sell the property. Okay, so we need to know that. And the trustees of the trust would be the ones signing the purchase and sale agreement. You need to make sure. Now, did we ever get you tax ID numbers for these trusts?
Yes.
Okay, great. So you then need to make sure there's a bank account opened up in the name of your trust under your existing tax ID number. Yes. You also need to make sure there's a bank account opened up under your late husband's trust. Now, I'm going to say it was probably under his existing tax ID number, but because he died, that trust is no longer a grantor trust, so it is going to have a new tax ID number.
We already did that.
Excellent.
Right.
Associated with the remainder share.
Right. Uh-huh.
Excellent. All so far so good. So now both trusts sign off, the trustees, on the purchase and sale agreement, and the money will come in to both trusts. There'll be 2 checks cut at the closing, 1 to each trust, and you will deposit them into these respective bank accounts. Now, would there be an income tax problem? Before you do a 1031 exchange, I'm not saying not to, and you're certainly allowed to, but before you do that, the thing you want to do is one, the assets that went to your late husband's trust, if it's sold after his death, there was a step up in basis. So what is this property worth that you want to sell?
About $1.5 million.
So let's say 1.5. So the basis is $750,000 already, plus half of what you guys paid for it. All right? So that's a huge savings on the capital gains tax front. So the half that goes to your husband's trust likely will have no capital gains tax associated with it. Okay? So that's huge. The other half that goes to your trust, if it's not your primary residence, and I suspect it's not, will have whatever your basis was when you paid it and all your capital improvements. So you have to run those numbers to find out what the gain is. But the important thing is there'd only be tax on that gain. So likely you really only need to do a 1031 exchange for the half in your trust. The other half you don't have to because there's no gain. Plus, since it's not a grantor trust, you may not be able to do a 1031 exchange on the half that's in your husband's trust because it's no longer a grantor trust, which is okay because there's no tax on that. But the half that goes into your trust, yeah, go buy a $750,000 property into that trust, your trust, by having the money go out and the new property come in. And then you have deferred the gain on the asset that on the portion of the gain that went to your trust because you're still alive. So that's how I would play it. You're certainly going to need some guidance on this and some help on it. But at the end of the day, this arrangement allows it to be flexible. And yes, the money would go back into the trust and then you use it to buy it. So hopefully, folks, that's helpful. Hopefully it's helpful for you as well. But if you need to, you might want to give us a ring, maybe get you hooked up with a 1031 exchange expert. But folks, this is a great question. And for her, she's learning that it can be done. And that's what needs to be done. Just got to understand the dynamics. And folks, these people did their planning. They provided for how their children are going to get their assets. We're giving away a brand new guide, How to Leave Assets to Beneficiaries, this month. This guide is so important for you if you're just beginning your estate planning and you're saying, well, geez, what are my options in terms of leaving my assets? And these trusts that are in here explain the language that you can use to leave them. What if I want to, protect it from future creditors? What if I want them to get it over time? What if I want to make sure they don't get divorced in the future and lose their assets? How can I, what if I've got a second marriage? What are my options there? It will help you get started if you've not done it. And you know what? Even if you've done your planning, you get the guide because then you can look through your trust, see how you're leaving it, and then maybe get some ideas on how to amend or modify your trust. And yes, you can do that even if it's a revocable or an irrevocable trust, at least the Medicaid kinds of irrevocable trust. Get the guide, folks, 866-848-5699 or legalexchangeshow.com. You can download it there, 866-848-5699 or legalexchangeshow.com.
Todd, I had asked you a question previously about, hey, what happens if you add a child as a joint account holder on, a bank account or a brokerage account?
Yeah.
Is the same situation true if you add them onto a deed for a property, or does that present a whole different set of problems?
Yeah, you're good today with these questions. That's a whole
Thank you.
different set of problems.
Thank you.
Yeah, right? Very different on that one, folks. And first of all, I'm cringing inside about the thought of doing that. Just so you know where my answer is headed, right?
Well, you're actually cringing on the outside too.
I am too. Yeah. Well, yeah. I do that sometimes. So if that's the case and you want to do that, don't do it. Here's why. If you add a name to the deed, you now have made a completed gift. Remember earlier with the joint account, I said, you didn't make the completed gift until they actually take the money. Here, you made a completed gift. So now you got to file a gift tax return. You're the giver. Remember, the giver's the one that pays the tax, not the recipient. So now I've got to pay a gift tax potentially, plus I gave it away. Now it's subject to the creditors of my child. But more importantly than that, what if I want to sell it in the future? Like here, this one of my clients that just called on the radio, right, said they want to sell. Look how much control they kept in an irrevocable trust, allowing them to do all those transactions, selling without any issues. You put it in the hands of the children, and it is going to now need their permission to sell it. And we don't even have time to talk about all the income tax ramifications that are going to go along with that. Folks, my answer is don't do that.
Mr. Lutsky, thank you so much for joining us today.
Always a pleasure.
This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing & Armstrong do not endorse each other and are not affiliated. Leaving assets to your beneficiaries is a critical piece of any estate plan. Cushing & Dolan has written a new guide that may help you avoid unnecessary mistakes that can cost you dearly in the long run and ensure that your assets are protected for generations to come. An example? The federal estate tax exemption has increased by nearly $1 million from 2023. That could lead to a larger inheritance for your family members. There are several strategies in this new guide that will help you learn how to make the right decisions about your distributions at the right time. Cushing & Dolan have been helping New England families for more than 30 years. Let them help you too. Call 866-848-5699 and get their brand new guide called How to Leave Assets to Your Beneficiaries. That number again is 866-848-5699. Or you can request the guide online by visiting LegalExchangeShow.com. The proceeding was paid for and the views expressed are solely those of Cushing & Dolan. Cushing & Dolan and or Armstrong Advisory may contact you offering legal or investment services. Cushing & Dolan and Armstrong Advisory do not endorse each other and are not affiliated.